I see people starting to join. We're just going to give it 1 minute for others to kind of trickle in. Okay, it's 12:01. We're going to go ahead and get started. I'm sure others will keep coming in for the next few minutes, but we want to stay on time. So welcome everyone. We're going to go ahead and get started. First off, thank you all for joining us for our Climate Change Law 101 program. This program is being put on by the Environmental Law section and the New Lawyer section of the California Lawyers Association. So this panel is a part of our Intro to Environmental Law series that has been running for a few years now. And this panel specifically is in preparation for our climate change conference that is taking place on April 7th at UC Davis School of Law. And registration is now open for that conference. And I don't think we have a link to it in our presentation, but our wonderful CLA staff is going to put it in the chat. So thank you for that, Adrienne. Kara, if you could proceed to the next slide, please. Thank you. All right, so I'm just going to do a few introductory slides before we get into the main content. First off, the California Lawyers Association is a nonprofit voluntary organization dedicated to the professional advancement of attorneys practicing in the state of California. Currently, it has 18 sections of different subject matter areas. And there's a part of that is the California New Lawyers section, which represents all lawyers in California in their first 8 years of practice. And its mission is to advance practical skills, leadership and pro bono activities, networking, and to meet the needs of the diverse community of new lawyers. And then lastly is the environmental law section, which advances the quality, breadth, and availability of information and services related to environmental law, natural resources, land use and energy, and enhances the profession by cultivating a well-informed, collegial, and diverse group of lawyers and law students throughout the state. So again, this program is being put on by ELS and NLS. Next slide, please. So just a few quick ways to get involved. There's lots of opportunities for this. So one, you're doing right now, attending webinars and in-person events such as the Climate Change Conference that's in the chat, the Yosemite Conference, this 101 series, and the numerous networking events that we have. You can also earn MCLE credit through online videos or self-study materials, submit articles and publications, watch the free videos on CLA's YouTube channel, which this series is actually on that YouTube channel as well. Participate in student negotiation and writing competitions, attend our book club that usually has the authors as well participating in the book club, and applying to things such as our Summer Diversity and Inclusion Fellowship. Next slide, please. So now we're going to turn to today's program, which is the Climate Change Law 101 program. I'm Paige Samblene, and I'm an associate at Brownstein Hyatt Farber Schreck. I focus in land use and CEQA, water rights, and water quality work. And today I have the pleasure of having with me Kara Horowitz, who is the Executive Director of the Emmett Institute on Climate Change and the Environment at UCLA School of Law, where she also directs the Environmental Law Clinic. And the Emmett Institute was founded as the first law school center in the nation focused on climate change law and policy. And just one more note, we will have some time for questions at the end of the panel. So feel free to save your questions for then or put them in the chat as we go. And with that, I think I'm gonna turn it over to Kara.
Thank you so much, Paige. And thank you to the section and to CLA for putting on this series. I know my law school students appreciate it, and so do I. The section has really been a tremendous resource for environmental lawyers throughout California and continues to be. And so I appreciate all of your work, and I'm grateful to be here today. Thanks for the opportunity to talk about climate change law. So I've been tasked with giving an overview of climate change law in the United States in just about 40 or maybe 45 minutes. The first thing that I'll say, of course, is that this is an impossible task, although one that I happily took on. Impossible because climate change affects so much of everything we do in our society and so many of our communities. And therefore, climate change law really is lots of different kinds of things. We really can't be anything like comprehensive in our overview today. So instead, I'm going to try and do three things with today's talk. The first thing I'm going to do is talk about climate change as a regulatory problem, talk a little bit about the characteristics of climate pollution and of climate change as a problem that make it difficult to regulate. Then I'll talk about I'll give an overview of the ways that policymakers have tried to grapple with the problem of climate change through legal tools. And spoiler alert, there are many such ways. So we'll just touch on the breadth of them. And then I'm going to go a little bit deeper in just a few places where climate change law is developing in ways that I think are interesting or high profile. We'll talk about a couple of really high profile Supreme Court cases, for example. But I want to just be explicit about the fact that I won't be anything like comprehensive in describing all of climate change law, because that's really just too big a thing. I'll end by talking about California's ambitious climate change programs a little bit, and with some thoughts on the Paris Agreement too, sort of just for fun to throw that in at the end. So let's go with that overview. Again, starting with the question of environmental law in the US and its origins as a solution set for traditional pollutants, by which I mean traditional air pollutants, traditional water pollution, for example. This slide depicts a really classic historical moment when a river in Ohio was so polluted with petrochemicals and other toxics that it literally caught on fire. This is a photo from 1952, but this river didn't catch on fire just once or just twice. In fact, this was such a routine occurrence because the pollution of this river and other rivers across the United States was so significant that on the right here, you see that local officials actually affixed a permanent sign to the Cuyahoga River sign declaring the river itself flammable, which is pretty extraordinary. This is an example of the way that one of the reasons why US environmental law sprung up in the way it did. US environmental law, which is federal statutory law, is really a creature of the early 70s, sprung up in part in response to these sorts of very palpable, very local, very tangible pollution problems that communities began to find unacceptable in the middle of the 20th century. If we think about the characteristics of some of those traditional environmental problems that really inspired the birth of US federal statutory law to deal with environmental problems, they have some common characteristics, and I'll spend some time talking about them, in part because I want to then contrast the way that greenhouse gas pollution is in contrast to these more traditional forms of pollution. So traditional forms of pollution tend to be pretty local, by which I mean they tend to be caused by local sources of pollutants, local sources of air pollution, local sources of water pollution, and then they tend to have their impacts or their worst effects also then felt locally by those communities. They tend to be pretty palpable. You know, you can see the river burning, you can look outside your window in Los Angeles and often tell that it's a very smoggy day. They tend to be quick acting. There isn't a very long lag between when a pollutant enters the environment and when the community begins to feel the harmful effects of that pollutant, for example. And for a lot of these reasons, they also can often be solved locally or regionally, by which I mean, if a community gets together and devotes the resources to constraining local sources of pollution, it can make a meaningful, often fairly quick difference in the level of pollution felt by that community. Again, all of that I emphasize as a way of contrasting it in some ways with climate change pollution, with carbon dioxide and other forms of greenhouse gases or GHGs, many of which, or all of which, are invisible and odorless. So they're really difficult to sense. They're slower acting. There's more of a lag between when the pollutant is emitted and when communities around the globe begin to feel the worst effects of that pollution. That's a lag in time. There's also a jurisdictional or geographical lag. So pollution that's emitted in the United States can cause really significant harms all the way around the world. So the geographical tie between sources of pollution and the effects of that pollution isn't as tight as with traditional forms of pollution. And for that reason, sometimes the harm isn't as immediately apparent. There are lots of sources of greenhouse gases, so many, in fact, that it becomes much more difficult to think about comprehensive ways to control them. In many ways, our industrial societies have really been built on the backs of an economy that, that is run with and because of fossil fuel energy that results in greenhouse gas emissions. And local impacts don't depend solely on local emission levels of pollution. And so that has all of these characteristics of greenhouse gases as a pollutant really affect the political economy of solutions that one might try to find and apply legally to the problem of this pollution. Now, these are not insurmountable problems. So I also have on the slide a couple of pretty fun examples of activists and advocates trying to overcome some of these barriers. We have advocates who in Copenhagen at one of the climate talks in 2009 erected a balloon that was an attempt to actually show what a ton of CO2 looks like as a way to get around the fact that it's typically really intangible. What is a ton of CO2? At the bottom, we have a pretty famous instance of the president of the Maldives in 2009 hosting a cabinet meeting literally underwater in an effort to make more tangible what the risks were to his country from sea level rise. So folks try and get around these problems, but they do present a problem for regulators. I also want to pause here and note what I think is probably not a problem, or much less of a problem than has sometimes been described for regulators in the climate change space, and that is information. At this stage, I actually don't think that we suffer from a lack of understanding of the problem of climate change or a lack of understanding of what we need to do to tackle climate change. Maybe that was the case decades ago. At this point, I think if folks are raising lack of information, it's more of a red herring, because we have decades of reports talking about what GHGs, greenhouse gases, do in the atmosphere, what their effects are on communities around the globe, what sorts of warming we might see from different levels of greenhouse gas emissions, and what effects that warming might have on our world and our community and our natural resources. So information isn't, I think, a barrier at this stage. We understand that humans have pushed the climate, as this Washington Post headline says, and as a UN report that it was based on said, into unprecedented territory. The UN chief, when this UN report was released a couple of years ago, called the report a code red for humanity, quite famously, and pointed to what we now understand to be the really significant effects of climate change that we are already feeling, and that which will get much worse over decades to come. Global greenhouse gas emissions are continuing to rise despite these understandings. The last 7 years are the hottest years on record globally. And we are already feeling many of the effects of climate change that science over the past few decades had predicted we would feel. Many of us in California have lived through just devastating and unrelenting and unprecedented wildfire seasons, for example. As another example, despite our really wet winter this year in California, our water managers continue to tell us that we're going to see real problems with our water supply in California in the decades to come, in part because we anticipate that the Sierra snowpack will slowly disappear over time because of warming temperatures. We also see really significant public health effects to community members, especially those most vulnerable, to the elderly, to the young. These public health effects are coming because of extreme heat, so temperatures in our communities and our workplaces that we're just not adapted to deal with. They're coming in part because of additional risks from infectious diseases or from additional ozone that comes with rising temperatures, all of which is to say there's a real host of harms to communities that are quite tangible that we're already feeling, and that are leading our regulators and have led our regulators to think quite seriously over the last decade or two about how to control the problem of climate change. Which leads me to the meat of the conversation, which is what are the tools, the legal tools that are available to address the problem of climate change? I'm going to do a kind of law professor thing right now and try and group the legal tools into a bunch of different buckets as a way to understand the range of tools that's available to address the problem of climate change. Here, I'm going to credit my really fabulous colleague, Professor Jim Salzman, who's an environmental law professor with me at UCLA Law. He and his colleagues have come up with one way to categorize these legal tools. He calls it the 5 Ps, and you see the 5 Ps on the screen here. Most traditionally, we have prescriptive measures. You might sometimes call these command and control regulations. They're used, each of these tools is used, of course, to address a range of environmental problems. Command and control measures might take the form of orders either to do something or not to do something to regulated parties, such as, thou shalt not jeopardize the continued existence of an endangered species, or thou shalt not emit more than X amount of pollution when you're undertaking your activity. But you also have other kinds of regulations. You have what you might think of as property-based regulations, by which we might, for example, create tradable permits or rights to permit, as California has done with its landmark cap and trade program, which we'll talk about in a bit. You might try and create either monetary incentives or monetary penalties, so payments or penalties, to try and incentivize behavior that society wants or disincentivize behavior society doesn't want. These penalties or payments could take lots of forms. For example, either tax penalties or tax credits. Litigation liabilities can be thought of as another kind of penalty that's imposed for pollution, for example. Other ways to internalize costs or to incentivize behavior that we want. And then there's a whole category of environmental regulation that you might think of as persuasive regulation or information-based regulation. So these are disclosure requirements, for example. In California, you can think of Prop 65 requirements as falling in this bucket. You can think of NEPA or CEQA, environmental impact assessment requirements and disclosure requirements, as falling in this bucket. I'm pausing here because this is one way to think about the real range of different kinds of climate change regulation that already exists. Each of these kinds of tools has already been used, and I'm sure will be used in the future to try and tackle the problem of climate change. So under prescriptive tools, for example, we now have requirements under the Clean Air Act. We'll talk a little bit about these in more detail in a bit. We now have requirements under the Clean Air Act that cars can't operate while emitting more than a certain amount of CO2 as a prescriptive matter. We also have California having created a California cap and trade program for GHG emissions as a form of property-based regulation. We'll talk in a bit about the Inflation Reduction Act, which is a big blockbuster new federal statute that Congress just enacted in the last year that operates largely through payments and somewhat through penalties to incentivize the transition to a cleaner economy. And then in the persuasion bucket, we have things like SEC disclosure requirements by which companies are required to assess and disclose to investors the degree to which they're susceptible to climate risks. We also have, NEPA and CEQA requirements that relate to climate change and climate change impacts, for example. And so each of these tools and many others has been used and will continue to be used to tackle the problem of climate change. As I said, there's a real range of diverse, dynamic, and developing legal tools that policymakers are using to tackle the problem of climate change. And I'm not going to talk about them all. I want to flag at this slide that there are even whole buckets, whole classifications of climate law that I'm not going to spend a lot of time talking about, but that I want folks listening to the webinar to understand exist. I'm going to spend some time talking about mitigation tools, by which I mean laws that are aimed at reducing emissions of greenhouse gases, right? There are also increasingly adaptation laws that relate to climate change. So inevitably, no matter what we do with our emissions from this point forward, we have locked ourselves in to a world of warming that is quite different from the world that we have gotten used to in, as we've grown our society to date. And we're going to have to adapt to that newer world in order to decrease the harmful impacts of climate change on many communities around the globe and here at home and here in California. And so adaptation law is a whole body of climate change law. I'm going to flag it. I'm not going to talk a ton about it. But for example, here in California, there are a whole bunch of new initiatives to help communities create climate resilience hubs, to help community members deal with episodes of extreme heat or energy grid instability or wildfires or other impacts that may be related to climate change. And those sorts of measures exist, and I just want to make sure that they're on everyone's radar, even if we don't talk about them a lot through the rest of today's presentation. With that, I am going to jump in to my two areas where I'm going to spend a little bit more time on federal US environmental law. And those two areas are in the Clean Air Act, and I'm going to talk a little bit about the Inflation Reduction Act. So the Clean Air Act I'm choosing because it is the US federal statute that has been used, I think, most successfully and most ambitiously in order to tackle the problem of climate change head on, even though indisputably it was not written when climate change was understood to be a really significant problem. It has been interpreted to allow for regulation of greenhouse gases in ways that we'll discuss, and has been used to regulate greenhouse gases in ways that are pretty effective. And then we'll also talk about this new blockbuster climate legislation, the Inflation Reduction Act that passed last year. Let's start with the Clean Air Act. So the Clean Air Act, many of you know, is a sweeping, very broad federal statute. It has lots of provisions. It has provisions that tackle mobile sources and some that tackle stationary sources and some that tackle a range of even different pollutants and different sources. We're going to focus on just a couple of areas in the Clean Air Act, and we're going to start with mobile source provisions. And the reason we're starting with mobile source provisions in this talk is because that's where EPA started when it first began to regulate greenhouse gases under the Act, under the Clean Air Act. And the statutory provision up on the screen, Clean Air Act Section 202, the mobile source emission standard statutory provision, was the first source of authority that EPA exercised to regulate greenhouse gases under the Clean Air Act. And the source of authority is again up on the slide. This is the provision that says that EPA shall establish motor vehicle emission standards for any air pollutant which in EPA's judgment causes or contributes to air pollution, which endangers public health, essentially. Not surprisingly, early advocates of ambitious EPA action on the problem of climate change identified this language in the Clean Air Act as language that really imposed a duty on EPA, even before it was thinking itself that it wanted to go in this direction. Imposed a duty on EPA to tackle greenhouse gases from cars. Advocates took the view that greenhouse gases are air pollutants under the Clean Air Act. Clearly that greenhouse gases reasonably may be anticipated to endanger public health and welfare, and clearly they're emitted from motor vehicles, right? And so took that fight to EPA, submitted a petition to EPA requesting that EPA regulate in this way. EPA famously denied that petition at first. And that's what led to the blockbuster Supreme Court decision of Massachusetts versus EPA, which many of you may have heard of. It was the first big landmark sweeping Supreme Court decision that grappled with the problem of climate change. It came out in 2007. Plaintiffs were state, cities, and environmental NGOs who had been making those arguments to EPA that EPA needed to regulate emissions from cars under the Clean Air Act. Defendants were EPA and other aligned parties, making arguments about why greenhouse gases, among other things, should not be considered to be air pollutants within the meaning of the Clean Air Act. And very famously, the majority sided with the plaintiffs in this case, holding that, in fact, greenhouse gases are air pollutants under the Clean Air Act, and holding that EPA must regulate greenhouse gases from cars unless it could come up with a reason grounded in the statutory text for failing to do so, different from the many reasons that EPA had put forward in the case for declining to regulate. This led to a real revolution in EPA's approach to regulating greenhouse gases under the Clean Air Act, and really opened the door for widespread regulation under the Clean Air Act of these new pollutants, now that we understood them to be pollutants as defined by the Act. So very quickly after this case was decided, and under the then relatively new administration of President Obama, EPA finalized its endangerment finding for greenhouse gases. So it made an official declaration that yes, greenhouse gases are air pollutants that endanger the public, and then we're going to do something about them. It began to regulate mobile sources of greenhouse gases as required by the Act. Notably, California also played an important role in this story because of California's special authority to regulate greenhouse gas emissions and other emissions from cars. I won't get in, I don't think I have time to tell too much of that interesting story. But for those who are curious about the backstory of the fight over Massachusetts versus EPA, the case, and the story of regulation of greenhouse gas emissions from cars more generally, I'll just recommend my colleague Richard Lazarus's book, Rule of Five, which tells the Massachusetts versus EPA story really well. Notably, once EPA opened the door to regulation of greenhouse gases under the Act, post Massachusetts versus EPA, that began to open another series of authorities within the statute itself to regulate even stationary sources for their greenhouse gas emissions. So EPA then next began to regulate stationary sources for greenhouse gas emissions too, including an attempt to regulate greenhouse gas emissions from what is the largest, continues to be the largest source of greenhouse gas emissions in the United States from any single sector. And those are emissions from existing fossil fuel powered power plants. And EPA tried to do that through the Clean Power Plan. And next, I'm going to tell the story of the Clean Power Plan and how that led us to our next big blockbuster Supreme Court decision on greenhouse gases and climate change. And that's the West Virginia versus an EPA decision that came out just this past summer that many of you may have heard of because it's made real waves, both in environmental policymaking circles and in administrative law circles more generally. So where did the West Virginia versus EPA case come from? What's it really assessing? It came from EPA's attempt to turn its regulatory attention to stationary sources of greenhouse gas emissions through the New Source Performance Standard Program, which is the program that's governed by Section 111 of the Act. We won't get into too many of these details, but for now, just know that under that section of the Act, EPA sets performance-based standards for facilities that emit air pollutants that endanger public health and welfare. We now know that GHGs are such pollutants. And under Section 111, EPA is required to set an emission standard for those sources that's based on the best system of emission reduction that has been adequately demonstrated, considering cost and other factors. That's the statutory standard that EPA is required to use as it creates a new source performance standard for these sources, for GHGs. And EPA did that. Again, under the Obama administration, it put forth something it called the Clean Power Plan. It was aimed at tackling, again, the elephant in the room for GHG emissions in the US, which was existing power plants. Existing power plants can be hard to tackle under the Clean Air Act. The Obama administration figured out, it thought, a way to do so through this NSPS 111D program. And it set an emission standard for these fossil fuel fired power plants that was, again, based on this best system of emission reduction. It did it in a particular and kind of interesting and ambitious way. Rather than just define an emission standard for these sources that was based on what each power plant could do within the four corners of its property by itself, just looking, for example, at each individual power plant and ways to tweak the operations of that power plant to make it more efficient, which is the first tool in this little 4-tool toolbox that's depicted on the slide here. EPA did something more ambitious than that, that would have allowed it to create even, or to achieve even greater emission reductions. It said, sure, regulated sources need to make themselves more efficient on the footprint of their plants themselves, but we're also going to look at the entire electric grid as something that's connected, that's related to each other. And we're going to create a standard that acknowledges that, in fact, electricity sources can shift from dirtier sources of energy like coal-fired power plants to cleaner sources of energy like renewable energy generation plants pretty easily, given the operations of the grid. And in fact, grid operators and electricity generators make these shifts all the time, from cleaner sources to dirtier sources to cleaner sources, based on all sorts of conditions on the grid on any given day. And so, taking advantage of that ability to shift, EPA created a standard under 111D that relied on such shifts to achieve further emission reductions. So it created a best system of emission reduction that actually required the electricity grid to shift over time to cleaner sources of energy. This set up the West Virginia versus EPA fight. The West Virginia versus EPA fight was a fight about the bounds of EPA's authority under 111D to require this kind of generation shifting from dirtier sources of energy to cleaner sources of energy under this provision of the Clean Air Act. And the question that the court asked was really, can EPA lawfully determine under this section of the statute that the best system of emission reduction is one that requires this kind of generation shifting between and across sources of electricity? And as you all know, if you were paying attention in the summer of last year, the Supreme Court answered that question in the negative. It said, no, EPA can't do that. EPA has attempted to create a standard under 111D that the statute doesn't support. It found against EPA here in a majority opinion that was written by Justice Roberts. It held that EPA's regulation was unlawful. And the reason, the rationale that the court used to get to this decision, was pretty interesting, and is what a lot of commentators have seized on as in fact, one of the most interesting things about the case going forward. Because the court really used this case to expand a doctrine called the major questions doctrine, which is a relatively new constitutional law doctrine that the court now uses to assess and to cabin often administrative authorities when administrative agencies are trying to do big, novel, new things to address complicated problems in ways that might not be entirely clearly authorized from the face of the statute that they're implementing. In a major questions doctrine case, the court said, and notably, we're still figuring out collectively what that means exactly, which cases are major questions doctrine cases and which ones aren't. But in a major questions doctrine case, the court will demand an especially clear mandate from Congress before approving the exercise of administrative power that's being reviewed. And here, because the Clean Air Act text, which again, as a reminder, requires that EPA create the best system of emission reductions, because that text wasn't an especially clear mandate approving the regulatory approach that EPA was taking here with respect to generation shifting, the court struck the ball down. Why am I spending a little bit of time on this in a in a relatively quick presentation on climate change law in the United States. I won't spend that much more time on it, but I do think it's worth noting that the administrative law approach that the court took in West Virginia versus EPA, striking down EPA's exercise of authority here, has ramifications, not just for environmental law, of course, across a range of different administrative law exercising authority, but in particular, because in the climate change context, agencies are often trying to stretch their authorities, maybe in ways that weren't particularly foreseen by Congress when Congress first enacted whatever statute the agency is working with. We didn't understand climate change to be a problem in the early 1970s when a lot of these environmental statutes were at first enacted. Agencies often find themselves trying to grapple with big societal problems like climate change, using existing authorities a little bit creatively and maybe pushing the bounds of those authorities a little bit. This is really the court's attempt to crack down on that ambitious use of administrative authority. And so has pretty significant ramifications for what EPA and other federal agencies might be able to do in the future to try and tackle climate change using traditional environmental law statutory techniques. All of which brings us to the Inflation Reduction Act that I want to talk about next. So the Inflation Reduction Act is a massive bill. It was passed last summer. Many people call it the most ambitious, important piece of climate legislation that Congress really has ever passed, despite the fact that it doesn't have climate change anywhere in or near its name. It's a massive spending bill. Analysts have estimated that its spending is likely to be around $485 billion in total, the spending that it authorizes at the end of the day. That's 485 billion with a B, the majority of which will go toward financing clean energy projects, electric vehicle charging structures, building energy efficiencies projects, transportation projects, a bunch of different kinds of projects that are all aimed at collectively decarbonizing our economy, including industrial manufacturing. In the scheme of the 5 Ps that we talked about at the top, this one is clearly regulation by payment, right? So this is not prescriptive, traditional command and control regulation. This is really using more carrots than sticks. This scheme, therefore, responds nicely to 2 trends that are underway. It responds nicely, of course, to our political moment in which finding consensus in Congress for more traditional forms of command and control regulation is probably very unlikely or nearly impossible. It also responds nicely to the movement in the judiciary that we were just talking about to really constrain ambitious uses of traditional authority by agencies. This spending or this regulation by spending approach is much less likely to be vulnerable to judicial challenges than traditional regulation under, for example, the Clean Air Act of climate change problems. And in fact, it remains to be seen how effective this regulation by spending approach in the Inflation Reduction Act will be. But modelers who've taken a look at the likely effects of the IRA and other bills tell us that it is likely to get us pretty far toward achievement of what the US has announced its climate goal is for the midterm. President Biden announced a climate goal of getting to 50% below the country's 2005 emissions by 2030. That's not that far away. You'll see that goal reflected in the horizontal line on this graph from some smart folks at Princeton who've been modeling the potential effects of the IRA. And you'll see the effects of the IRA modeled in the purple line. You'll see the purple line gets us almost, but not quite all the way to that goal by 2030. We'll get there, potentially before 2035, at least according to this model. The IRA is a big deal. And again, how effective it is at achieving our climate and energy transition goals really remains to be seen and depends a lot on implementation questions. At this point, with just a few minutes left, I want to move on to the topic of what California and other localities have been doing to tackle the problem of climate change, and then just say a few words about the Paris Agreement. So I'll note that, interestingly, Local, by which I mean subnational, state, or even more local climate action, should be theoretically difficult to enact for some of the reasons that we talked about when we talked about the characteristics of GHG emissions as a pollutant. Local abatement actions pose local costs. The legal scholar Jonathan Weiner has written, yet they deliver essentially no climate benefits, because if a small locality is working alone, it can reduce its emissions all at once. It's really not going to have a significant effect on global levels of GHG emissions or atmospheric concentrations of greenhouse gases. Nevertheless, we see all the time local jurisdictions, including California, working really aggressively and ambitiously to tackle the problem of climate change. The question is why. I have up on the slide a few reasons why jurisdictions might be incentivized to do this. They might really want tech innovation within their borders. They might really want to grow their local economy for green tech, for example. They might care an awful lot about securing co-benefits of health for their residents. A whole set of reasons might justify local action on climate change. And in fact, we see jurisdictions around the globe, as depicted on this slide, taking really ambitious, often coordinated climate action. That climate action can look at the state and local level like a bunch of different kinds of things, just like it can at the federal level. It can look like renewable energy mandates or energy efficiency programs or market-based programs or controls on land use or transit. In California, we have at this point, decades-long bipartisan history of embracing pretty ambitious mitigation goals, many of which are reflected on the slide here. These have been embraced by Republican administrations and Democratic gubernatorial administrations, relatively politically popular regardless of political party in California. And California is among the jurisdictions that has really led the way in showing that one can decouple one's economy, continue to grow one's economy, even while shrinking greenhouse gas emissions. So most famously in 2006 or so, the state pledged to return its statewide greenhouse gas emissions to 1990 levels by 2020. At the time that that pledge was made, many folks had no idea whether California could achieve that goal or could achieve it consistent with a growing economy. California blew that goal out of the water in many respects, met that goal early, continued to grow its economy. And so that set the path for California down an even more ambitious mitigation regime. I think it's fair to say, once again, regulators, policymakers, the regulated sector, and others are not entirely sure how California will get to its next stated goal, which is to get to 40% below 1990 levels by 2030. But an awful lot of smart people are working on that problem as we speak. So to wrap up here, I'll talk about, I think I'm not going to have time to talk about state nuisance suits, although they're incredibly interesting. I'll just end with a few minutes on the Paris Agreement itself. Many of you have heard of the Paris Agreement. It's the primary international law agreement by which countries around the globe have come together to try to cooperate on the problem of climate change and agree collectively to reduce levels of global GHG emissions to levels that are consistent with the stated goals of the agreement. Those stated goals include keeping the globe to within 2 degrees Celsius of warming above pre-industrial levels, or ideally even lower than that to within 1.5 degrees of warming. Under the Paris Agreement, countries make pledges for how much they agree to reduce their emissions over time. Those pledges are what we call bottom-up pledges. They come from the countries themselves. They're not imposed as a top-down measure by any overarching, governing body. Countries are coming to the table with the pledges themselves. Sort of an analogy might be as folks come to a dinner with, potluck contributions. And then we do a calculation to see where all the pledges that countries have come with, where those pledges get us. And you see one version of an analysis on the screen here of how far the pledges that have been made so far do get us. We see the effect of the pledges as bending down emission curves to 2100 on this slide. The current pledges under the Paris Agreement are depicted in that pink or salmon colored part of the graph. Notably, better than we would have been without existence of the pledges, but still pretty far from where countries understand we need to go with our emission reductions in order to reach the 2 or 1.5 degrees Celsius goals that the countries have set. And those goals are depicted in green on the slide. And so there's a big gap under the Paris Agreement between what countries have pledged to do and where countries need to go with their emissions in order to achieve the goals that countries have agreed we should achieve. That gap is well understood. Some call it the Paris Agreement gap. And it remains to be seen whether the mechanisms for ratcheting up ambition over time that the Paris Agreement also puts into place will be sufficient to incentivize countries over time to ramp up their pledges in the way that's needed. I'll end just by noting one of the most remarkable things that I saw in Paris when I was there for the 2015 negotiations. I had the pleasure of taking a group of students from UCLA to Paris to participate in the negotiations that led to that agreement. And among other things, we saw this remarkable piece of art that was created by an artist from Iceland called Ólafur Eliasson. This artist had brought chunks of a Greenland glacier to Paris for the 2-week period of the negotiations of the Paris Agreement and placed these chunks of Greenland glacier on a Parisian street in a public space and arrayed them like a clock face so that at each hour of the clock face, there's another chunk of Greenland ice. Place them there at the beginning of the 2 weeks and then just let them there over the 2 weeks to melt while the negotiators did their work, met with each other, wrangled over what the details of the Paris Agreement might be, threatened to walk away from the table if the Paris Agreement wasn't coming to be, right? During all of that, as they could look outside their windows, they could see Greenland ice literally melting in front of them. And this was, again, a public place. Members of the public could come and touch the Greenland ice and watch it melt while all this was going on, as could the negotiators themselves. And I want to end my talk here simply because, to me, this was, first of all, an incredibly effective piece of public art. It really made it impossible for negotiators and others to ignore the stakes of global climate change as they undertook their negotiation work. But it also reminded me that no matter what each of our talents is, there's a way for each of us to plug meaningfully into the fight against global climate change and its worst impacts. Whether we're artists or lawyers or musicians, if we're paying attention and we care about the problem of climate change, there are ways that we can get involved. And so I'll leave it with that and encourage all of you to find ways in your own practice to get involved if you can. Thanks, Paige.
Kara, that's such a great way to end that. I really like that outlook of collectively coming together, regardless of our professions, and trying to tackle this huge issue. And thank you for providing such a great summary within a very limited amount of time about climate change law. And so first I want to, there was a question, I think, about the book club that was already answered, but I just wanted to go a little bit more into this. So the environmental law section does have a book club, and usually it goes out in the email blast or also on the LinkedIn pages, but there's an environmental law section book club webpage on our website that has Sarah Dudley's contact information. So if anybody wants to, has a book recommendation or wants to know more about upcoming book clubs, feel free to go there. So I just wanted to address that quickly. But we do have questions in the chat for you. So I'm going to go to the first one about your discussion about local involvement in climate action. And the question is, how local is local according to Wiener? What about cooperative energy programs in communities?
Yeah, and I see it was Kim who asked that question. Thanks, Kim. So, Wiener's thinking about the political economy of enacting climate control laws. And so I think the point he's making applies perforce, applies even more strongly the more local you get, right? So the smaller the community, the harder it might be, theoretically anyway, for politicians in that community to agree to take whatever hits might come from constraining the emissions of greenhouse gases in that community, knowing that the proportion of greenhouse gases as a global metric that they control is really quite minuscule. And so, I think the point he's making lives on a spectrum, right? The smaller the community, the smaller its share of global greenhouse gases, the harder theoretically it should be or might be for local politicians to agree to constrain local GHG emissions. Of course, the point I and others are making is that despite that theoretical difficulty, we actually see cities and subnational jurisdictions surely all the time taking action on climate change. And so it becomes an interesting question of why. Why are cities willing to take action on climate change, given their relatively small effect on the problem of global climate change writ large? And the answer, I think there are lots of different answers, and probably you, Kim, and others on this call can provide as many of them as I can. But I think surely one of the answers is that we found that there are actually benefits to cities to taking these kinds of actions. So community members actually like living in environmentally conscious, environmentally friendly communities sometimes. I think there are also sort of economic benefits that flow from becoming the kind of community that, for example, embraces electric vehicles and maybe doesn't have as many, polluting vehicles on the road. There are ancillary co-benefits to public health, even from the reduction of traditional air pollutants that come from those measures. And then there's also, surely, at least among some communities, a moral sense that we understand climate change to be a real problem. We understand ourselves to have a role in finding a solution, even if we can't provide the full solution. So it's some mix of those things and probably other dynamics in play, I think.
Yeah. Okay. So the next question is, how do you become an environmental lobbyist?
Oh, that's an interesting question. There are probably others on this webinar who could answer it actually better than I could. I think the first thing I'll say is that these fights over what environmental laws, and in particular climate change laws, should look like are not going anywhere anytime soon. I think it's clear that climate change is a problem that we're going to have to be grappling with for quite a while. And so there will always be winners and losers in any regulatory package that gets passed that is an attempt to deal with climate change. And that means there will always be private sector clients and others, public sector clients too, who are willing to pay folks to go up to to Sacramento or out to DC to try and wrangle the best deal that one can for one's clients as these wholesale societal changes are being made. For example, the transition to cleaner sources of energy is the transition of a lifetime for lawyers, for lobbyists, for electricity generators. This is a transition on a scale. If the transition occurs in the way that the drafters of the Inflation Reduction Act hope it will occur, it's a transition that's going to happen fast. It's going to happen on a large scale, and there will certainly be private sector winners and losers. So how do you become one of the people that those private sector or public sector clients hire in order to go to DC and Sacramento and argue your case to the policymakers? I think you begin to understand our legal systems really well. You understand what's at stake. It doesn't hurt to be the kind of person that that can schmooze really nicely. I mean, all the ways that one becomes a lobbyist apply to how one becomes an environmental lobbyist too. But I think a baseline that a baseline of understanding of the current play of environmental law is probably a pretty good baseline to come to that job with.
Yeah, that's great. Thank you. We do have a few more minutes and we have a few more questions. So I'm going to try to get through these as quickly as possible with some closing remarks at the end. But the next question is, do you think the Toxic Substances Control Act is a possible source of command and control regulation of greenhouse gases that could withstand the West Virginia case?
It's a really good question. I think I'm going to punt on this one. So my colleague, Tim Malloy, for those of you who know him at UCLA Law, is really a TSCA maven, Toxic Substances Control Act. He would be able to answer this question better than I can. I think it's a good thought, and I don't really know the answer. Sorry, Brian.
Yeah.
I can give a more general version of the answer, which is after West Virginia versus EPA, what's clear is that administrative agencies trying to tackle the problem of climate change using existing authorities probably have to be able to point to a pretty specific grant of congressional statutory authority to do the thing they're trying to do. If the thing they're trying to do seems at all big and consequential and maybe new, again, it's a little unclear what makes for a major questions doctrine case. So, as you answer this question about TSCA, what you're going to want to look at is how clear is the grant of authority within TSCA to do the thing you're trying to do? How much does it look like a radical reworking of a large segment of our economy versus, incremental change of the sort that the agency usually makes in other rulemakings, et cetera?
No, I think that's a great answer. I think you answered it very well. Okay, so next question. In terms of international cooperation, what do you think is realistically the most effective tool of enforcement to get countries to make good on their GHG carbon neutral pledges?
Yeah, so I'm going to answer this as someone who spent a while before I came back to academia working in international environmental law contexts. And I'm going to share that it was incredibly frustrating to work in those contexts day to day, in part because there are no effective tools of enforcement in the international law world. There just aren't. International law is a creature of consent. You can't really make countries do things in an international context that they don't want to do in any meaningful way. And so I came to the conclusion, as have many others, this isn't just my thought, that the most effective tools of international cooperation in this space don't actually have anything to do with what we might think of traditionally as enforcement. Instead, it's really about incentives or naming and shaming or other forms of international pressure, right? And so part of what the Paris Agreement does, I think probably smartly, is it sets up a system by which countries make these pledges, then they have to announce these pledges publicly. Then they're required to report publicly on how they're doing with respect to those pledges. And then periodically, the scientists have to get together and tell countries collectively how we're faring in the aggregate, given all the pledges that have been announced versus what countries say their goal is. And so all this public data is about naming and shaming and creating a sense of international public pressure as much as it is anything else. And maybe that'll be enough to get us where we need to go. But if it isn't, there's no enforcement mechanism that's going to come down like a hammer on these countries.
Okay. Well, thank you, Kara. Do you mind proceeding to the next slide? That's the law conference, Yosemite Law Conference slide for me, please.
Yeah, let's see.
Within the last minute, I'm going to try to wrap up just a few things. So first, the environmental law section's annual environmental law conference at Yosemite is taking place on October 19th through the 22nd of this year. And it's at Tenaya Lodge. And it's very, very close to Yosemite National Park. The conference features 27 educational sessions and is just an incredible conference to come and learn and network and meet people in this space. I highly recommend going to this conference for anybody who's interested. There's a link there with more information. And then next slide, please. Thank you. Okay. Two other things to wrap up: the Diversity and Inclusion Fellowship Program is an incredible program, and it essentially provides law students the opportunity to work their summers at a governmental agency or a public interest environmental law organization, 8 to 10 weeks, and there's a $7,500 stipend. I was a fellow, and I have nothing but incredible things to say about this program. I highly encourage any student who is interested to go to the link, and feel free to follow up with any questions that you have. Applications are due this fall. And then lastly, I think the mentorship program, which is new, is on this slide. So it just started this past year, and it essentially pairs newer attorneys with more experienced attorneys. And it's been a hit this year. Applications closed December 15th, 2022, but applications will open again for the program for next year in the fall. More information is in that link. And I think that's everything that I wanted to say quickly. But if anybody has any questions, feel free to reach out to us. I think our contact information is on this last slide. So if anybody has any questions or wants to learn more, feel free to reach out. And yeah, have a great Friday, everybody.
Thanks, Paige. Thanks, everybody.
Thank you.